Good afternoon or good evening. Thank you for still being here, despite the hour and the very long yet interesting day. My name is Tamar Megiddo, and I'm very happy to chair this last panel of the day, titled Rights of Victims in Eau de Combat. We have 3 presentations and 4 speakers, and I will introduce each of them as they speak. They will each have 18 to 20 minutes, but no more than that. So I'll strictly enforce that, so that we will have some time for the Q&A, and we are running late, so we'll have to keep the Q&A tight as well. Apologies in advance. So our first paper is titled Humanitarian Displacement, the Misappropriation of Humanitarian Principles to Justify Mass Displacement. And we have 2 authors on this paper. The first is Dr. Eitan Diamond, who is the manager and senior legal expert at the Diaconia International Humanitarian Law Center here in Jerusalem. He serves on the managerial boards of the Public Committee Against Torture in Israel and Parents Against Child Detention, and on the editorial board of the Journal of International Humanitarian Legal Studies. And his CV is very extensive. So very briefly, he's worked in various capacities with UNICEF, the Office of the High Commissioner for Human Rights, with Gisha, the ICRC, and B'Tselem. And he's a graduate of the Hebrew University and the LSE and Tel Aviv University, and the author of many publications. His co-author is Ellen Knoll, who will be joining us online, and she's a senior legal advisor at Diaconia at the Jerusalem desk. Ellen has previously worked as legal operational advisor for the ICRC in Geneva and in Afghanistan, and as a political officer for the Swedish Ministry of Foreign Affairs, most recently in Mali. She's a graduate of Yale, Oxford, and Cambridge, and also has authored multiple papers on IHL and dispute resolution and human rights law. So thank you both, and the podium is yours.
Great. Thanks a lot, Tamar. I won't hold you to your word about us each having 18 to 20 minutes. But yeah, so thanks. I also appreciate all of you who stuck through to this late hour. Appreciate the commitment. I'm going to pass on to Ellen in a moment, but we thought that before doing so, before passing on to Ellen to present the first part of our paper and perhaps the structure of the argument that we make, I'll try to locate the argument we're responding to within a wider family of lesser evil arguments. This mode of argumentations, lesser evil mode of argumentation, appeals to humanitarian considerations to justify practices that engender significant human suffering, insisting that the harmful practice is justified because it causes less harm to civilians than an alternative mode of operation. Such argumentation actually has a long genealogy. It was used, for instance, as a justification for dropping an atomic bomb on Hiroshima, not so much for Nagasaki, but for Hiroshima, suggesting that a land invasion into Japan would have caused more casualties amongst Japanese civilians. The Israeli military has used this kind of reasoning to justify an array of practices, ranging from nighttime arrests of children in the West Bank, the use of white phosphorus in Gaza a few wars back, the use of human shields in all kinds of contexts. The basic argument, again, is to maintain that these modes of operation are less harmful to Palestinians as well as Israeli soldiers, and that they're therefore should be preferred. One of the problems with this reasoning is that it sometimes or quite often disregards other less harmful alternatives. So sometimes there's a still less evil, so to speak, way of pursuing a military advantage, or even a possibility to avoid evil altogether. And it's important to be cognizant of this. Our paper addresses a form of lesser evil argument, asserting that causing mass displacement of civilians in hostilities is permissible and even mandated as a way of sparing them from the effects of attacks in the place where they reside. Arguments of this kind have been raised to suggest that the repeated displacement of Palestinians in Gaza, where about 1.9 million people have been displaced, many of them more than once, 1.9 out of 2.3. So the argument suggests that this was effected lawfully by issuing advance warnings or perhaps by implementing evacuations, and that this is actually a sort of humanitarian practice that should be lauded. The conceptual, and I should underline, it's conceptual, so we don't advance a factual or political. There was some talk about emotional argumentation. Ours is very much a conceptual analysis. The conceptual analysis that we advance in our paper brings this assertion, let's say, into question. And I'll pass on to Ellen now to present the first part of the argument.
Thank you so much, Eitan, and thank you for inviting us. Just to check, can you hear me okay?
Yep.
Yes.
Okay, excellent. So our paper examines IHL restrictions on the forcible displacement of civilians. And as Eitan mentioned, we are looking specifically at the legality of displacing civilians by issuing relocation directives ahead of an attack or a siege. And this scenario then is based on Israel's practices in Gaza, but also southern Lebanon. Now we see that on the one hand, it's clear that forcible displacement involves significant harm to individuals and communities. And yet it's sometimes put forth as a humanitarian imperative that is permitted, if not even required, by IHL. And while IHL in some cases permits or even requires relocating civilians to protect them against the dangers of hostilities, the considerable harm that displacement entails, we argue, must also be accounted for when determining which courses of actions are lawfully available to parties to a conflict. Because if all that is necessary to render forcible displacement lawful under IHL is to threaten to attack an area where civilians reside, then IHL has not only failed to protect against unnecessary suffering, it has provided a justification for it. The space for this kind of misappropriation of humanitarian principles to justify the infliction of harm, we argue, can be reduced by resolving ambiguities that persist in IHL. And in our paper, we try to resolve some of these ambiguities, examining, first of all, the field of application and meaning of the prohibition of forcible displacement, and secondly, the extent to which the rules on the conduct of hostilities protect against forcible displacement. Now, turning to the prohibition of forcible displacement, we address three basic questions. When does the prohibition apply? If it applies, does it cover the type of conduct under consideration, namely displacement caused by a relocation directive issued ahead of an attack? And third, might the displacement be lawful as an evacuation? With respect to the first question, Article 49 of the Fourth Geneva Convention and customary IHL prohibit the forcible transfer or deportation of protected persons from occupied territory, with an exception that we shall get to later. In addition to this explicit reference to occupied territory, the applicability of the prohibition is subject to the general condition that for the Fourth Geneva Convention to apply in the first place, the affected person must be in the hands of or in the power or control of a hostile party. Now, while it's widely construed to encompass persons present in the territory of a hostile party or territory occupied by a hostile power, it is doubtful that mere capability to manipulate people's movements in foreign unoccupied territory, such as by issuing relocation directives and launching attacks, would suffice to bring the affected persons into the hands of that party. Meanwhile, in non-international armed conflict, the treaty and customary IHL versions of the prohibition, for obvious reasons, make no reference to occupied territory, which, as we know, is a concept belonging to the legal framework of international armed conflict. But perhaps less obviously, they do not set an explicit requirement of effective control over territory or persons. In fact, the International Criminal Court has confirmed that territorial control is not necessary to violate the prohibition applicable in NIAC, or for the commission of the war crime in NIAC, of ordering the displacement of civilians. Now, this leaves an apparently illogical gap in protection, with the prohibition applicable in NIAC and occupied territory, but not in IAC, absent occupation. And from a humanitarian perspective, such conclusion is deeply unsatisfactory. After all, capacity to cause and to prevent involuntary displacement is not dependent on territorial control. Now, this apparent protection gap is somewhat lessened if the functional approach, which you have discussed earlier today, to the law of occupation is accepted. But there are still clearly limits to the functional approach. And it might be stretching it too far to hold that state A, which is involved in an IAC with state B, is bound by obligations specific to the law of occupation, namely the prohibition of forcible transfer, if state A makes no attempt at invading or controlling foreign territory, and the only control it exerts over civilians in state B is through remote communication and long-distance strikes. Now, it could be that forcibly displacing civilians in another state is necessarily unlawful anyway, under the jus ad bellum or the rules on the conduct of hostilities, and therefore no specific prohibition is required. However, overlapping protection is generally preferable to the risk of a protection gap, especially given the tendency of parties to armed conflict to interpret restrictive rules narrowly. Moving then to the second question, and assuming that the prohibition applies, that is an IAC in the case of occupation or a NIAC, the second question is whether the conduct under consideration is covered by the prohibition. To recall, this is a speech act instructing civilians to leave their homes, coupled with the threat of harm from an attack unless that speech act is complied with. An initial objection that we describe in the paper draws on the historical distinction in IHL between so-called Geneva and Hague law. The placement of the prohibition in the Fourth Geneva Convention has been taken by some to imply that it does not regulate conduct forming part of the hostilities that is subject to Hague law. Accordingly, it would not apply to displacement caused by a warning issued in connection with an attack. Now, arguably, this proceeds from a too simplistic understanding of the relationship between so-called Geneva and Hague law. The applicability of these two strands of IHL is not mutually exclusive. The occurrence of hostilities and the applicability of the rules on targeting do not release a party from obligations it has toward persons protected under the Geneva Conventions. And what is more, the prohibition of forcible displacement foresees the temporary evacuation of civilians in situations of hostilities, thereby accommodating implementation by a party of its precautionary duties under the targeting rules. Now, the existence of this exception is itself strong indication that the prohibition continues to apply in situations of hostilities. That leads to the third and last question. Could the conduct nonetheless be lawful as an evacuation? In both occupied territory and NIAC, the temporary evacuation of protected persons is expressly permitted under certain conditions. The three main being: the relocation must be absolutely required by imperative military reasons or the security of the civilians concerned. It must respect certain geographical and temporal limits, and it must be carried out in safety and dignity. Regarding the first condition, it has been suggested that if a warning is followed by an attack that in fact places civilians in danger, their relocation will necessarily be justified by reference to their security. However, this would imply that a party can render displacement lawful simply by making it dangerous for civilians to stay in place. And such an interpretation would undermine the very essence of the prohibition of forcible displacement. We argue that if the attack in relation to which the instruction to relocate is issued is unlawful or would be unlawful were it not for the removal of the civilians, the relocation cannot be justified on the basis of the security of those affected. In that scenario, the danger that civilians seek to avoid by relocating is an unlawful attack that must be suspended or cancelled. And it's well established in case law that forcible relocations cannot be justified by reference to a danger created by a party's own unlawful actions. If the planned attack is lawful, but the civilians are offered no safe place to relocate to, or their transfer is itself a threat to their security, then again their displacement cannot be justified by reference to their security. Now, if instead a party tries to justify the removal of civilians for imperative military reasons, these reasons must clearly be in pursuit of a lawful military objective. And what is more, to be imperative, there must be overriding military considerations that make the transfer absolutely necessary. So it's not enough that the party would simply gain a military advantage by removing civilians. And even then, the temporary relocation must, to the greatest extent practicable, be carried out in satisfactory conditions of health and safety, avoiding the separation of families. A final note is that we recognize there might be a concern that requiring compliance with these conditions of lawful evacuation to render the removal of civilians lawful will discourage parties from taking precautionary measures that remove civilians from the dangers of hostilities, thereby increasing the risk to civilians. However, we argue that assigning part of the cost of forcible relocations to the responsible party should reduce the risk of relocation directives being overused to render military operations more convenient or palatable while neglecting the significant harm of displacement. It should also incentivize parties to explore other precautionary measures that reduce the risk to civilians without exposing them to the harm of displacement. Thank you, and I will now pass on to Eitan and the second part of the paper, which explores the IHL rules on the conduct of hostilities.
So I start 5 minutes. Okay, so I'm not going to explain our whole argument or even the abbreviated version that I prepared because we don't have much time. So what I'll try to do is just to kind of quickly outline some of the basic structure of the argument. So, I mean, as Ellen has observed, the IHL rules on the conduct of hostilities do allow and even require belligerents to effect the displacement of civilians in certain circumstances, for example, by giving advance warning of an impending attack. Ellen also explained that when occurring in occupied territory or in a non-international armed conflict, forced displacements must satisfy the conditions of a lawful evacuation that she specified. And the question that we address in the second part of the paper that I'm going to briefly outline is whether the rules on the conduct of hostilities impose additional requirements that a belligerent party would have to satisfy in order to lawfully effect the displacement of civilians. So in addition to the prohibition on forcible displacement, and this would be the case not only in non-international armed conflicts or in territory that it occupies, but also in the non-occupied territory of an opposing party to an IAC. So in that kind of area where we identified an apparent gap in the law. Two initial observations, and then I'll just outline the structure of our argument without developing it. The first is that our inquiry proceeds on the well-founded assumption that forcible displacements can be expected to cause significant harm to civilians. And it's concerned precisely with those incidents where it does, where there is an expectation that it will cause that kind of harm. So you can think of circumstances where issuing a warning won't cause anything more than perhaps an inconvenience. We're not dealing with those cases. We're talking about the cases of the type painfully evident in Gaza, where displaced peoples endure many kinds of hardships and deprivations that result in the types of civilian harm that IHL is concerned with. A second observation is that the IHL rules on the conduct of hostilities, as you will know, represent a balance between military necessity and humanity. And this balance is reflected in the content of specific rules and should also inform the interpretation and application of the law in general. And as you also will know, at least the practitioners here, striking the balance between these kind of competing values can be a challenge. But it's not a challenge when one of the values is altogether missing from the equation. So harming civilians when this does not serve a legitimate military or for that matter, humanitarian purpose is undoubtedly prohibited. You don't have a balance when there's nothing on the other side of the equation. So accordingly, it's unlawful to forcibly displace civilians simply to implement a project of ethnic cleansing, for example, to annex foreign territory. These are obviously illegal objectives, to facilitate attacks on civilian objects, or to collectively punish or terrorize the civilian population. So these are the easy cases where there's nothing on the equation. The question that we grapple with, and I'll just outline now, are the cases where there is a legitimate military consideration at play. And what we argue is that the rules establishing general protection from harm in military operations, so these provisions that relate to this wide category of military operations, as well as more specific rules regulating attacks, apply to forcible displacements and subject them to various requirements that we cluster under the labels of necessity and proportionality. Now, I would like to explain to you how we go about that, but I don't think I'm going to manage in the time that we have at our disposal now. So maybe in the Q&A, we can return to that. Some of you, the participants, have a copy of the paper in which we developed the argument in detail, and would very much welcome your comments on the way we developed this argument. But I'll stop there for now so that I don't go into the time of other. Thanks.
Thank you, Eitan. And thanks for sticking to the time despite the difficulty. Our second paper is titled Between Rights and Reality, the Detention of Gazans in Israeli Camps During the War. And the author is Sausan Zaher, who is a Palestinian human rights lawyer based in Haifa. In addition to managing her private human law firm in Haifa, she also serves as legal strategic counsel for human rights organizations and serves as an instructor at the Human Rights Clinic at Tel Aviv University. Sausan has previously worked for many years in Adala, the legal center for the Arab minority rights in Israel, and she is a graduate of the College of Management and the American University in Washington, D.C., and was a fellow in multiple U.S. institutions. Please. To make the long story short.
Okay, good evening, everybody. It's courageous these days to invite Palestinian speakers. So if at any point you don't like what I say, just blame Professor Yuval Shani for inviting me. I actually didn't author any article. I am here to speak from a practitioner point of view, and all the more so from a Palestinian human rights lawyer's view, especially as a litigator in the Supreme Court in a lot of landmark cases on behalf of Palestinians. And what we see on the ground, it's a little bit awkward after October 7 to even talk about human rights law or international law. It doesn't matter what discipline it is, because the concept of law has been eroded, has collapsed basically. And we saw that on the ground in many and in different areas and different fields and different kind of violation, especially against Gazans after October 7. And the test case that I would like to talk about is basically the detention policy of Israel of Gazans, not only Gazans, because we saw that as human rights lawyers and organizations, we saw that basically being applicable against all Palestinian detainees, whether they are from the West Bank or East Jerusalem, or whether they are citizens of Israel. The fact that you are Palestinian led to a united policy of restricting and limitation of basic rights that are in contrast and in violation of Israeli law and international law. Now, after October 7, immediately after, the same day or even a day after, hundreds of Gazans disappeared. Gazans that had permit to work in Israel, Gazans that had permit to get health services in different health facilities inside of Israel, they disappeared. No one was able to know where they are. No one was able to provide an exact list. No one was able to give an answer to the families, to the hundreds of calls to all organizations to know where their dear ones were. And at some point, human rights organizations, Israeli ones and Palestinian ones, including Adala, and this is important because I will address that later, submitted a habeas corpus petition on behalf of, that was the first one, and it was almost 2 weeks, if I'm not wrong, after after October 7. They weren't able to gather information. They weren't able to gather the petitioners. So the petition was submitted on behalf of the parents or the families of 10 people who disappeared, and more than, or at least 100 stories and cases of other people, other Gazans that disappeared were included as cases, not as petitioners, in that same petition. And basically the cause was that there was no legal cause to detain them in huge numbers. We didn't know, human rights organizations didn't know the exact numbers. They didn't know where they were held. They didn't know what the legal cause was. They weren't able, they were prohibited from meeting lawyers, of course, not to mention speaking with their own families. All the permits, it doesn't matter, like in a sweepingly manner, were cancelled, all the permits that were cancelled. And basically there was a sweeping policy of collective punishment, no matter whether the person, the Gazan person, was involved or not involved in the on the day of October 7. And of course there's no need, I don't even want, I think it's a little bit awkward to start even mentioning based on Article X and Y, of course, because it is clear that even based on Israeli law, not even to mention international law, the Israeli detention policy violated all basic rights, no matter where they were anchored. So the meaningful norms, legal norms that were set up in Israeli law, in case law, or even the laws and international law, basically totally collapsed. Now I know that most of you probably know the events of these petitions, but what I want to illustrate is what was the role of the Supreme Court in basically giving a legitimacy, even if intervening with the petitioner's cause, but did it have any kind of legitimacy to the violation or to the preservance of the violation of the rights of Gazans who were detained? And I'm talking not only about the Nukhba, which is the Hamas personnel that were detained, that had direct part in the Hamas attack on Israel on that same day, but we're talking about, as I said, the workers, we're talking about people who were sick who got health care in Israel, and we're talking about West Bankers, East Jerusalemites, and Palestinians in 1948. Until August 1st, based on data from Hamuked, there are almost 10,000 people from the Palestinian occupied territories, Gaza, West Bank, East Jerusalem, and the West Bank, who are detained until today in Israeli detention, no matter if they have been involved or not. And everyone is under the definition of unlawful combatant, which basically puts them in a very hybrid, a weird definition of being the enemy but not a combatant, but then you're unlawful. So even the international, even like the Israeli Supreme Court did basically address this issue in a very old petition, because the law was enacted in 2002 and was critiqued by human rights organizations here and international wise. But So basically the sweeping detention of everyone and putting them under and detaining them under the definition of unlawful combatants, even though most of them didn't have any involvement with the attacks themselves. So after a short while, there was another petition, habeas corpus petition by Israeli and Palestinian human rights organization, mainly Adala, because Adala was the main organization that used to basically to join petitions in these cases. And this second petition was submitted on behalf of 568 workers. It took a while. When I say a while in emergency and war, a few days is a while. And if we compare it to urgent petitions that were submitted in Jenin operation, military operation in 2002, urgent petitions meant that in few hours you are in court with the robe starting even your arguments. So the very mere fact that the court did not, in these cases after October 7, schedule the hearings immediately or even after 48 hours, that means a lot in terms of the in terms of how the court perceived the Israeli obligation based on Israel law and international law. So at some point after at least a week, the state submitted its written response to the court and said in that second habeas petition, habeas corpus petition, it said that basically there is a cabinet decision to release and return most of the detainees. Only then the petitioners knew, based on the state response, that we were talking about 2,900 people who were detained from Gaza, that they will return, and they did return except for 150. Now, of course, here as well, we're talking about a disappearance. No one knew where they were. No one knew where, no one had an exact list. Even the human rights organizations didn't know the exact number of people who were detained until the state submitted its response. The unlawful detention, the revocation of freedom, the collective punishment, the arbitrary detention of all these people, and then on November 2nd, all of them were returned to their families in Gaza. Now, a few months passed, and in May 2024, which is a very important timing, human rights organizations, only Israelis, no Palestinian organizations, submitted the petition against the Sdei Teman detention center. And as you know, Sdei Teman has been established or has been reoperated by an order from the government a day or two after October 7, and basically gave the authorization to operate an arrest or a detention center in Sdei Teman that will enable, based on the unlawful combatant law, to detain the Gazans that were arrested. Again, we're not talking about the Nukhba, which is a minority number in terms of number. We're talking about the majority Gazans that were arrested from Gaza and brought to Israel to Sdei Teman. And the timing is very important because, again, no one has any data from what's going on in Sdei Teman because no one was able to visit Sdei Teman or most of these detention centers. No lawyers, of course, no family visits, no calls, and no one really had any clue what was going on. Only with the exposure of media outlets of testimonies from former Israeli soldiers, former Israeli medicals that gave treatment to detainees, Gazan detainees there, and only from international media outlet that basically the severe violation the conditions, severe conditions of what was happening in Sdei Timan started to basically show up. So and of course there was no testimony from any Gazan detainees. The petition was submitted based only on the testimonies from the Israeli people who decided to talk about the issue, fortunately, and who testified about the severe conditions, which are basically not conditions, they are inhuman, degrading. They reflected how Gazans were basically treated in an inhuman and degrading way, like surgeries without anesthesia, reasonable conditions of basic healthcare facilities, not even having adequate number of staff or qualified staff, 24 hours handcuffing with plastic handcuffs, severe punishment for very irreasonable, very reasonable felonies like talking with each other 24 hours, eyesight coverage, long hours, difficult standing in difficult positions or being held in difficult positions, enclaves without cells, no clothing, no food almost. And of course this is it's a little bit weird to talk about the articles of international law because the gap between reality and norms get wider and wider, but of course hygienes based on violation based on Article 85 of the Geneva Convention, water and food, Article 89, clothing, Article 90, and so on and so on and so on. And the question basically was legal. Was there an authority for the State of Israel to establish the arrest detention center in Sdei Timan in that way, based on the regulations and the law of unlawful combatant law? And what basically took my attention was the fact that, first of all, again going back to the timing, the court enabled and accepted requests, several requests, at least 5 requests from the state to extend the update that it can submit to the court about the situation in these detention. Now, we do know that indeed there were at least 900 people that basically, because of the time given to the state by the Supreme Court by accepting the motions, it enabled them to release bit by bit the detainees and lower the numbers to an extent. By the way, they were released, most of them, to Ofer, because they established a military detention center in Ofer. So they basically took them from one place to another place. And by the time that the court in September, 4 months later, saw that it was ripe timing to decide, it accepted the petition, but at that time there were only 24 Gazan detainees because the state was able to move them. Now, of course, this is a good step, but the question is, should the court, the Israeli court, ruling based on the rule of law, not international law, the Israeli rule of law, should it have the obligation to discuss the petition on a real urgent matter and not wait 4 months for those people, for the hundreds of people, to really be under torture? And what also attracted my eyes when I was reading the court decision is that the court, and I'm translating, basically posed the question like this: should the State of Israel abide by the rule of law, the Israeli rule of law? This never happened. The court doesn't ask itself whether the State of Israel should abide. They say, did the State of Israel violate the law? Was there any violations? Never it had posed such a question in this way. So again, it accepted the petition, but 28 people were there. Now, again, that was based on testimonies. By that time, May, June, we started as human rights lawyers and organizations to get to be able to visit. So a lot of us started to visit, and B'Tselem in August issued a very similar report, like a similar testimony, a report that reflects the testimonies that was in the petition, but this time from Gazans and Palestinians who were released. I myself was able to visit a doctor, a Gazan doctor from Auda Hospital, that basically told me that he was even brought in front of a judge, and the judge said that clearly there is no evidence against you being involved in Hamas, but there's a security threat if we release you, a threat to the order. Now, of course, what they wanted from him is more data about who is where and who is who in the Auda hospital, especially after he was asked to accompany when the IDF was in Gaza, in Auda hospital, he was asked to accompany the IDF to Tel Aviv, have a cup of coffee and talk more about what's going. He refused, and then he got arrested. So now there is a lot of we're talking about Gazans who I will take just 1 more minute, please. Now, why I'm saying all this, because the court, even if they accepted these petitions, even if they enabled the petitioners to submit, they basically had a role in the delay of hearing the petitions. Time matters when you're talking about torture and when you're talking about violations, like very basic violations. The second thing is timing, because the court did see that in January, with the preliminary order of the ICJ, it had to take action, but it wanted to take action in the way that it saw fit. So the Israeli court saw that it did have a very serious role in preventing the violation, it, for example, could have exploited its authority as an official visitor based on the law to go and make surprising or unexpected visits the day one that they knew, which was already in mid-October or in the end of October, when the first petition of disappearance, habeas corpus, was already submitted. It should have brought the suspicion that there was something wrong and that they should go and make those unexpected visits, but they did not. Now, another thing is that after the genocide case of the ICJ, we started to see that if before Adala or Palestinian organizations joined these petitions, now they are not part of, and I agree that, because yes, I think that there is a huge problem in trying to talk about law when there is when the perception of Gazans, not only Gazans, all Palestinians, is basically degrading and inhuman. And I want to end by the fact that despite the fact that the Israeli detention policy of Gazans in Israel was not a clear part of either the ICC procedures or the ICJ procedures, I do think, like other Palestinians lawyers, that it should be part of the genocidal, of the perception and the examination of the genocidal intention of this war, because the way that Israel, the IDF, is treating and violating, whether it's infrastructure, water, food, starvation, you name it, violations cannot be examined on specific and concrete violations, but there should be a holistic approach and examination of all the policies towards all Palestinians, including Gaza. Thank you.
Thank you, Sausan. So quickly, our third paper is the prohibition on forced displacement, the right to leave, non-refoulement, and the right to return, 4 sides of the same coin. Rovi, I'm going to be extra brief, is an associate professor in international refugee law at the University of Reading. How's that?
That's perfect. I'll just need a presentation on. You can read the rest if you want.
Okay. Perfect. Okay, that is great. So I stand before you and either going home or going to dinner or both. So I'm going to try and be uncontroversial and boring as I can be. And basically, what I want to do in this paper, what I am trying to do, is is to make two key claims, which I don't actually think should be particularly controversial, but given everything around this conflict is controversial, they probably are. And so the first is that the prohibition on deportation, we've heard a little bit about this in the first paper, does not qualify the right of individuals to leave any territory, and that includes the Gazan territory. And that is a right in international human rights law as well as in IHL. And the second, perhaps even more uncontroversial statement, is that the principle of non-refoulement or non-pushback at the border applies at the border. That is, applies at the frontier, and it is not qualified, as you were, by any future collective self-determination right. Or to put it differently, collective rights to self-determination in the Gazan context, I would argue, is co-opted by external actors as a justification for infringing what is an immediate and tangible individual right, and that is the right of individual Palestinians to leave a territory where there is a risk to their life or freedom. So this basically makes me unliked by virtually everyone in the world, and that's great. So let's just talk about the context, which I think we've heard earlier about factual context being in dispute. Perhaps this one isn't. We have mass internal displacement of Palestinians in Gaza following IDF evacuation. I've put orders in scarecrow marks. And we know that Palestinians who have sought to flee the Gaza Strip since October 7th have generally been physically prevented from doing so legally. I've emphasized legally. Some people have been smuggled, right, via either Egypt or Israel. And I reference you to the question I put earlier to the IDF legal advisor. Is clearly the possibility of them doing so as a matter of Israeli policy was not even considered, from what we gather, and definitely was not allowed. Some exceptions to this are Gazan residents who are foreign nationals, so they were able to come in almost on the assumption that they would then proceed to another country, or some stateless Palestinians that do have family members elsewhere. Actually, incidentally, my MP in Oxford Western Abingdon has family members in the Gulf who were able to get her family from Gaza to go to the Gulf via Egypt. So anecdotal but relevant. And we know, because we've all heard them, that there have been explicit calls by right-wing Israeli ministers and members of parliament for ethnic cleansing and the re-establishment of Israeli settlements in the Gaza Strip. And that plays a role, I would argue, later in some of the way in which the question of non-refoulement by Egypt has been analyzed and addressed and justified by international organizations. So that's the context. Now, why is this so unusual? It is unusual because if we look at this just random list of conflicts, because the world is such a peaceful place around the world in recent decades, this is the exception to the rule. The rule in the recent decade has been that individuals trying to flee a conflict would at least be able to do so in relation to one neighboring country, if not multiple neighboring countries. The most explicit and analogous example to questions around ethnic cleansing, which I will come to, is actually the one of Nagorno-Karabakh to neighboring Armenia via the Lachin corridor. So in the space of 10 days, in late September 2023, mind you, just a few days before October 7th, virtually the entire ethnic Armenian population of Nagorno-Karabakh had been displaced because Armenia has opened its border knowing full well that it's very unlikely those people would be able to return immediately to Azerbaijan. They're facing threats by Azerbaijan in that context, and nevertheless has done so, by the way, whilst filing urgent procedures in front of the ICJ in the ongoing case around the treatment of ethnic Armenians in Nagorno-Karabakh, saying that they must be allowed back, having a UN resolution saying that they must be allowed back, but nevertheless opening its border to allow them to come in, right? So that's and I've listed multiple other contexts. We all know about Ukraine and all of its neighboring countries, including Russia, in relation to ethnic Russians or Russian speakers in Ukraine. We know in relation to Sudan that has happened with Chad and with Egypt, as October 7th has happened. At the same time, there were still people crossing the border into Egypt, and we're talking hundreds of thousands in relation to both Chad and Egypt, and I've listed the other cases. I'll just make a footnote in relation to Syria, which is that there has been one population from Syria that has faced difficulties crossing the borders to at least two of its neighboring countries, Jordan and Lebanon, and we can all guess which one it is. It is stateless Palestinians living in Syria. So I will come back to that point. Now, lest I present a picture that is only partial, it's not as if there haven't been border closures in the past, or at least partial border closures. So there's been a paper about the UNHCR's responses to this, which I cite, which lists 5 of these cases in the 1990s and the early 2000s. And in all of these cases, there have been 3 types of, or at least 2 of the 3 types of considerations that have been invoked. That there is a security risk in allowing people in, that it's not facilitating burden spreading. In other words, that we want other countries to be taking people as well. And in all of these cases, the international community responded by enabling that in one form or another. And in the case of Kosovo and Macedonia, there has been an explicit invocation, the only one of those, that they do not want to partake in what may end up being ethnic cleansing. In all of those border closures, in the end, people were allowed to leave the territory. So I stand, I think, behind the claim that this is a very unusual case, that we are now, 15 months into a conflict where people are literally, and I'm quoting him, Jim Hathaway, trapped in Gaza, right? So let's take this as, I think, a factual basis for analyzing those 2 claims in the time that I have. So the first is, as I say, this tension between deportations and the right to leave. So I want to say, again, I think uncontroversially, that forced or constructive deportations are rightly prohibited in situations of conflict and occupation, but that equally it must not undermine the right to leave or to flee persecution or serious harm. And that right, in order to be given effect to, involves both the country they want to leave to, right, and that engages non-reformer that I'll come to, but also engages the space from which they want to leave. And without getting into the fuller discussion around the status of Gaza and occupation, it is very clear that Israel, at the very least, by controlling the question of whether people have legal permits to leave the territory and whether they're able safely to get to a border crossing, has at least the control over whether people would be able to leave to Egypt if Egypt would have allowed them in, right? So we can, I think, accept that. And so I would argue that means Israel has an obligation to allow those who want voluntarily to leave to do so. And I'll come perhaps in questions, if it comes to that, to the extent to which its own obligation is engaged in relation to allowing people into Israel for safekeeping during the conflict. So what is the risk here? The risk is that a state might actually do that, right? Israel hasn't. But if we want to analyze this, that you will have constructive deportation that is prohibited, that may be disguised as facilitation of voluntary departure. I think that speaks a little bit to Eitan's paper earlier as well, around where you can kind of create the conditions in which evacuation may seem like the necessary and humanitarian provision. As I said, I think I can kind of whiz through these bits quite quickly, because we've heard earlier about Article 49 of the Geneva Convention. I think it is the case that in relation, at the very least, to the functions around the prohibition on deportation, Article 49 clearly applies to Palestinians in Gaza who are protected persons within the meaning of this provision. As I said, the ICJ advisory opinion in July has found that there is an international armed conflict, at least between Israel and Palestine, has found that we have a situation of functional occupation. So the prohibition on individual mass forcible transfers is an absolute one, right? So, deportation. It says it's prohibited regardless of the motives. But we've heard earlier that undertaking total or partial evacuation may be permitted if there are either the security of the population or imperative military reasons so demand. And part of the reason I asked Brigadier General Katsir earlier, the question I did, was precisely because of that question of how do you conceive of the security of the population or imperative military reasons. Because if the analysis, for instance, is one that says that in order to execute your military operations in a way that ensures the security of the population, you cannot do evacuation within the territory. In other words, that it is impossible for material reasons to avoid displacement outside the territory, that it might be that the legal argument would be that in order to be able to legally undertake the military operations you want to undertake, whilst maintaining the security of the population, that evacuation outside the territory is required. It might be under that construction of Brigadier General Katsir's point. The point is that evacuation can only take place, whether it's inside the territory or outside, if people are guaranteed that they will be transferred back to their homes as soon as the hostilities in the relevant area in question have ceased. So this is not a requirement to return people to the territory once the entirety of the hostilities is completed. It's if there's a specific area where operations have concluded and there is no longer a safety consideration there, then you must return people to that particular area. And so I'll just jump to that other slide, right? So this is where temporality becomes so relevant, right? It's the question of what point a permitted evacuation, whether inside or outside the territory, actually turns into prohibited deportation. And here I do think that statements from ministers and others that indicate that people leaving will not necessarily be allowed back, and I would put it more strongly, that the absence of statements that are clearly indicating that people would be allowed to return, and there's interesting analogous situations, for instance, people who were allowed to leave Iraq under the American occupation, where the American Attorney General then, Goldsmith, was saying, what you have to do is ensure in the letter that give them permit to leave that they would be allowed to return, right? So the absence of a clear determination that people would be allowed to return raises suspicion that anyone being encouraged to leave or evacuated will not be allowed to return, which then leads one to conclude potentially that this would be a prohibited form of displacement, right? And I think that the really critical question, which I just pose it as a question rather than having a full answer, is how voluntary can voluntary departure really be in a context where the conditions that generate your departure are such where you either face life under terrible conditions, potentially famine and otherwise, or you're faced with the opportunity of leaving. That really voluntary, can we really construe it that way? That is a real challenge. And that is why, to me, the more important question in a way is where you flee to and what are the obligations of neighboring states, right? So that takes me to the second claim, the last 6 or 7 minutes, right? And the first thing I want to say is where I started with, that mass influx concerns do not qualify the non-rejection at the border legal obligation. So the idea that a lot of people are fleeing at the same time is not unusual in conflict. That is what happens in conflict. That is exactly the number of people who left Ukraine in the space of the first month after the 24th of February 2022 was higher, was about twofold the entire number of the population of Gaza, right? We're talking more than 4 million people have left Ukraine in the space of the first month. And we've seen similar patterns in the other conflicts that I've highlighted. And the second point, and this is where I think the real challenge arises, right, is that realization of individual rights not to be subjected to persecution or serious harm may facilitate or accelerate ethnic cleansing aspirations of a party to the conflict. So it may very well be that if Egypt had opened its border, it would be then fulfilling a degree of the wet dream of certain right-wing ministers in the government. And the problem with then relying on that as a basis for closing one's borders is that one, as I've said, is subjecting the very tangible individual rights of individual Palestinians with agency to escape a place of harm to the potential diminishing of a future right to their collective self-determination in their land. And that is a right, and that is obviously also a right that they have to return to that territory. That is not in dispute, and I may not go into that for time. It is not in dispute that individuals who are displaced from territory have a right to return to that territory. There's been numerous international resolutions to that effect in relation to virtually every conflict where there's been displacement in the last 30 years. And that right is not qualified by the fact that it's not an individual but a group of people who want to return. But we do not know whether that right will be realizable or not. It is true, Egypt doesn't necessarily know, but I would suggest that as a matter of international refugee law, the answer to this is very clear. This is an individual right, but also as a matter of general policy, to allow states to close their borders on this pretext would be an incredibly damaging development in international law. So why do I even make this accusation or presumption in relation to Egypt? Well, it is because Egypt has actually explicitly said so. So 2 weeks after October 7th, the Egyptian president has said that Egypt has affirmed that it is reiterating its vehement rejection of forcible displacement of Palestinians and their transfer to Egyptian lands, as this will mark the last gasp in the liquidation of the Palestinian cause. So in other words, an external actor here is saying to an individual Palestinian, we're not going to allow you in to escape Israeli indiscriminate, harmful, potentially criminal bombings because we are the guardians here of the greater Palestinian collective self-determination cause. That is fundamentally the crux of the Egyptian argument. And I would be less bothered if it was just the Egyptian argument. What I'm more bothered by is this list that I'm just going to put on this screen. Is that we've had 4 UN Security Council resolutions on the conflict that have passed, 11 that have been proposed. None of them mention a right to leave or non-refoulement. We've had multiple UNRWA statements, multiple UNHCR statements. They have all been silent on this particular conflict. We've had the Secretary General of the United Nations speak in October this year, 2 months ago, saying that there was an intention for Palestinians to leave Gaza, for others to occupy it, but there was courage and resilience of the Palestinian people and determination of the Arab world that avoiding this ethnic cleansing, right? So essentially I read this as tacit endorsement of the border closure, and the International Crisis Group has in fact said, do not push Egypt into allowing Palestinians in, right? So, and I've talked about the Israel stuff, and I know time is nearly up. I just want to say about the Israeli displacements, and I do think, and there may be disagreement in this room, that despite it being an enemy population, there are security considerations that can be taken into account by a party to a conflict where people want to flee. Israel does have non-refoulement obligations as well. I just think that realistically, if we look at the 2 cases in recent years where people have been displaced to a neighboring party to the conflict, they've been displaced to a party to the conflict where there are ethnic, political, or other alignments too, and it's very unlikely Palestinians would actually want to take that risk and flee to the place that is generating their persecution or their harm. But the obligation does exist. So I know we're done. So the different norms on non-refoulement are in the full paper. They are very clear in IHL, in refugee law, in international human rights law. And I just wish, and this is where I end, that international organizations would apply them equally. Thank you.
Yes. Thank you all very much. So, questions? Okay. So let's start. We'll just go around that.
I think my question is for Eitan and Ellen. You talked about the fact that a party cannot rely on a danger that it created as imperative military necessity in the case of evacuation. And I was wondering how you determine who is actually creating the danger. Is it the party that is embedding itself within the civilian population, or the party that is attacking that adversary? Thank you.
Thank you. My question is to Sausan. First, thank you. It's very important for me to hear your perspective. I have two comments. One, I think your argument is stronger when time lapses from October 7. In the first 2 weeks, it's a weak argument because there were not just the Nukhbas responsible and involved in what happened in October 7th, also Gazan civilians. And there was also suspicion that some civilians were aiding and abetting the perpetrators. So I think your argument is weaker in the first week, 2 weeks, take it whatever you want. The more time that elapses from October 7th, I think the argument is stronger, that Israel should have been organized to give all basic rights to detainees under Israeli and international law. And my second comment is, I mean, it's of course legitimate to speak just on, you're speaking about detention, just to speak about Palestinians detained in Israel. But if speaking in Israel, I would suggest saying at least one word about 100 civilians which are illegally detained in harsher conditions and murdered in Gaza. You don't need to say it. You can be strictly legal, but if you want to pass the different speakers spoke about the emotional part, not just the legal part, just a word about Israeli hostages would do more work than many legal and other arguments. Thank you.
Actually, my comment is to commented question to Eitan and Alan. First of all, Alan, I think you mentioned the atomic bomb in the Second World War as for the argument that it was done to save lives, Japanese lives in case of an event. It was you, sorry. Actually, the argument was that it would save American lives, not Japanese lives. And as recent research shows, the argument was actually correct. Richard Frank wrote about it, but that's just a side comment. My question is, I had a feeling that your approach can bring armies into damn if you do, damn if you don't situation. If you stage military operation in dense and crowded areas, then you'll be accused for excessive collateral damage, but when you evacuate people, you'll be accused for evacuating, let's say, because war is chaotic and they don't have a completely safe and dignified way to evacuate. And I think that if one wants that armies would actually adhere to IHL, then the instructions should be very clear and not confusing. And in my opinion, that's the one problem with your approach.
Thank you so much. I had a question also to Ellen and Eitan. Ellen, you mentioned other precautionary measures, and I would like to know very practically what they are. And Eitan, I would love to hear what your arguments based on necessity and proportionality are.
But there was no question, there was a comment, and well, I do refuse when people, especially after October 7th, with all due respect, really, to oblige me to talk in a very balanced way. I am not in a, maybe if I was in the beginning, in the early days of October 7th, I would do that, because as a human rights lawyer, I am against violations against innocent people, but at this timing, and again, getting to timing, I am not prepared to anyone obliging me for the order of balance to speak about anything that I didn't choose to speak about. Now, that doesn't mean that I'm against, but that means that this is a political comment, not a legal comment. I am Palestinian, and everything that I would say is from a Palestinian side, and that's what I said already from the beginning. And I think a lot of the Israeli discourse hasn't been balanced from a Gazan Palestinian perspective, and any request to balance it was basically denied. Now, The only thing from a legal perspective that I would address about the comparison between the civilians who are kidnapped in Gaza and about using the terms shvuyim, prisoners of war. Now, they are civilians, they are shvuyim, they are prisoners of war. But to balance that, I would also call all innocent people, civilians that are detained by Israel in Israeli detentions, also prisoners of war.
I'm not sure this.
So, yeah, no, so maybe Gaz's question, I think Ellen will take, and I'll take Dani and Manu's questions. So maybe Ellen, you go first.
Yeah, thank you, Gal. So the question was whether a party cannot rely on the illegal attack that it's conducting if the other party itself has committed IHL violations, basically. So by being in a densely populated area, it's forcing the other party to act illegally, and therefore that party should be allowed to evacuate the civilians. My quick response to that is that it's a basic principle that if one party acts unlawfully, that does not justify an unlawful attack by the other party, and therefore the other party cannot rely on the need to conduct an unlawful attack to justify an evacuation. And the basic principle is that it's not just an unlawful attack that is causing harm. What we argue is also that the evacuation itself causes harm and can therefore not be justified in circumstances where the attack itself cannot be justified.
Okay, so perhaps I'll take Dani's question. So first you had this observation about the atomic bomb. So there is actually a debate suggesting that it was both of those objectives. I'll just quote something from Michael Walzer about this, just about this point that you were saying, that it actually turned out that that this was a correct calculation. So he said, this is the quote, "To kill 278,966 civilians, the number is made up, in order to avoid the deaths of an unknown but probably larger number of civilians and soldiers, is surely a fantastic, godlike, frightening, and horrendous act." So that's maybe something to reflect on about that. Now, the point about damned if you do, damned if you don't, so that's not our argument. We're not saying that issuing an advance warning before an attack is something that should be avoided, because that might also result in harm. What we're saying is you shouldn't stop there. So certainly if you think that your attack is going, if there's a way of reducing civilian harm by issuing an advance warning, then you actually have an obligation to do so. But to say that that's the full scope of your, perhaps this will also in a way get into Manu's question, what we're suggesting is that you don't stop there. If the foreseeable consequences of issuing such a warning are that civilians are going to incur a great deal of civilian harm, and if it's possible to reduce that harm through feasible measures, for example, by affecting their displacement in the way that's required in order to affect a lawful evacuation, then you should do so. So if you can achieve the same military advantage, we're not talking about a case where you'd have to compromise your military advantage. If you can achieve the same military advantage by affecting a displacement, for example, through an advance warning, but you can, in addition to that, take all sorts of other measures, for example, restricting the geographical and temporal scope of the displacement, ensuring that certain humanitarian safeguards are provided, then you have to do so. And I won't get into the full details of how we go about that. And then beyond that, we also, as I mentioned, we also have this kind of reflection on the notion of proportionality. So proportionality is, at least the concrete rule relates to proportionality in attack, where you're supposed to weigh against each other the civilian harm that you expect, the anticipated military advantage, and if the civilian harm is excessive, whatever that means in relation to, what we're suggesting is that when you affect the displacement of many, many people, then it's important to also reflect on that as civilian harm. So there's going to be civilian harm incurred by the people who have been displaced. There's going to be additional harm caused by the attack in the area where they've been displaced from. And if that harm is still excessive in relation to the military advantage that you anticipate that you're going to obtain from the attack, then you have to, we would argue, either forego the attack or implement the attack in a way that would reduce the civilian harm. For example, by introducing those other temporal and geographical limitations, taking these measures to ensure that the humanitarian needs of the population are provided for. So that, in a nutshell, is what we mean by necessity in the sense of not more than is necessary. This is subject to feasibility, etc., and proportionality is the usual kind of concept. We're just extending it to also consider the harmful effects of, in a way, a precaution. I'm not sure that's developed so much, but precautions sometimes can themselves result in harmful effects. And what we're saying is that the rules on precautions should require you to consider those harmful consequences, not just say, oh, I've done something to mitigate the harm, so I have no further obligations. That's, in a nutshell, the argument. Thanks.
A comment to Ruby and a comment to Sausan. To Ruby, regarding the question whether there's a duty for Israel to accept the people fleeing, you should take into account that there's at least a position that states there's a customary international law that allows a country in war to deport all citizens of the enemy country. And the last source that is supportive of this view is the Commission of Eritrea versus Ethiopia. So maybe there's an exception for Israel in that regard. And now to Sausan, I want to disagree with Liron regarding his first comment that Liron disagree. I think that things are even worse regarding the first months of the conflict. I actually wrote a paper on it that is in a draft condition. So first of all, the Supreme Court rules that in a NIAC there's no duty to inform the family and the Red Cross of the arrest, which is completely not true IHL-wise. It rules that friends of a person do not have a standing in habeas corpus, and by doing so violates High Court decision 7/48, El Karbutri, meaning one of the first precedents of the Supreme Court. And just so people would realize before, how can you compare? The person detained in El Karbutri, Abu Laban, was the leader of the Arab population in Yafo. He's the person that signed the surrender with the Israeli forces. So he was a leader, and still it was argued that a friend of him has standing. Then he didn't do the most basic obligation of a court in habeas corpus to ask the government to show the legal basis for the detention. And after 3 petitions, we discovered that the government admits that they didn't have a legal basis for detaining those people, and it doesn't reprimand the government. So things are even more horrible than you describe regarding the first months of the war, and that's to comment to Liron's.
Yes, thank you. So these were very interesting presentations, and I have a lot to say to each of you, but I'll be mindful of it. I'll be mindful. No, I'll be mindful of the time. So for the phenomena for Ruvi, the point you maybe also for Eitan, I mean, and Alan, the point you made about the instrumentalization of Palestinians in terms of not allowing them individual refugee status in order to uphold the national interest. I mean, I think we saw also a shadow of this also with the initial issue of the Mouassi and the question of the evacuations to Mouassi, where there was also resistance. I think in order to uphold the prohibition against displacement, there was resistance on the part of humanitarian organizations to cooperate with the plans to transform Mouassi into a humanitarian zone. Eventually, it did become a humanitarian zone, you know, with all the caveats that apply. But I at least saw it initially as coming from the same family of upholding a general rule but at a price that could, you know, compromise the individual interests of people who have nowhere to go and need to be somehow they need a place where they can receive aid and assistance. The question I have for you, Eitan and Ellen, is on the issue of attack. I mean, it seems that you were applying here the framework of precautionary warnings, which are typically associated with individual attacks. But I think what we saw in this, also in Lebanon, but also in North Gaza, was a different, and at times also in Rafah, was a much broader approach, which says we are going to operate in the entire North Gaza. Okay, this is now the war zone, the North Gaza, and therefore I'm not sure it's really the framework is precaution. It's maybe constant care. Okay, maybe as a, and there is the question, of course, is it an order? Is it a, you know, is it a caution? So the question is, how do you even go about establishing military necessity? I mean, it's not really IHL. It's means and methods, but at such a high level of abstraction, I think it would be very difficult to make a case for the army. You shouldn't have come from the north. You should have come from the south in order to advance. I mean, I'm not sure that we have the, you know, the tools, the legal tools of analysis as proverbial lawyers, as simple lawyers to go about this. So I was wondering how would you deal with this sort of challenge?
Thank you so much. I wanted to comment and perhaps add something to Sausan and then ask Ruby a couple of questions. I'll try and be brief.
So just, yeah, please everyone try.
Just to encourage Sausan very much for bringing up this important topic of the Palestinian detainees that most Israelis are not interested in listening or hearing about. And to add that another criticism of this Deteman ruling of the ACJ was not just the timing of it, but also the merits and the fact that it only addressed the legality that is supposed to apply for such detention camps, but never answering the factual questions of where those laws actually prevented or disobeyed, which of course led to more occurrences of exactly the same kind of detention conditions than we're seeing right now. And to Ruby, I have two questions. One is, are you not concerned that should Palestinians be evacuated voluntarily from the south of Gaza, for example, through the Rafah crossing, that would then make the south of the Gaza Strip into a kill zone, as we've seen in the northern part of Gaza? Therefore, it's not just the voluntarily departure of the people leaving, but also the voluntarily or indeed the risk to the lives of those who choose to remain. And a second question is, how would you balance that with the Israeli argument when assessing refugee requests by Palestinians from the West Bank? Israel argues that Palestinians are in fact not eligible for refugee status because they are under the jurisdiction of UNRWA. Of course, now they're trying to retract that.
So, excuse me, the last questions, we're going to just move back to the panel because our time is just up. We'll give one.
Should I? Yeah. Well, probably more than a minute. But so let me actually tie Yuval's comment about instrumentalization with your second point about Article 1D and kind of the Palestinian special regime, because to some extent the argument around instrumentalization, you know, could be seen in the extent to which Article 1D, which is often kind of thought of in the first paragraph, which talks about exclusion of refugees who are Palestinians who receive protection or assistance from UNRWA from the wider refugee convention framework, but people conveniently forget Article 1D2, which said that if that protection or assistance has ceased for any reason, then Palestinians are ipso facto, by that fact, automatically convention refugees and don't actually need to meet the ordinary conditions of that provision. And there's been a lot of discussion whether there should be a wide interpretation of this, which ultimately then encourages or becomes a push factor from the territory and then undermines collective self-determination. So all I can say on that point and on Yuval's is that the Court of Justice of the European Union earlier this year, based on factual assessment that was done even before the last year, has said that basically UNRWA's protection of assistance has, for all intents and purposes, ceased in the Gaza Strip. And so as a consequence, virtually any Palestinian who previously was eligible or has received protection assistance from UNRWA and would make it to a convention respecting country, in my reading and the Court of Justice, would be ipso facto a refugee, subject to things like exclusion clauses on basis of terrorism or crimes against humanity, so Article 1F exclusions, which will apply to some Palestinians but not to the vast majority. I think that actually plays a role politically and from a policy perspective in not allowing Palestinians in, because I think there's a greater realization that that would exactly happen under the current conditions in Gaza, and arguably has happened in Syria as well, in places like Yarmouk and others, where in certain parts of the war in Syria, it was impossible for UNRWA to continue to operate. And I'll just make a very quick point on the enemy nationals on Ziv's point. I'm not sure it's entirely analogous in multiple ways. I'm not sure you can even classify Palestinians as enemy nationals for the purposes. I mean, that would certainly require you to consider them to be a state, which I think the same country wouldn't be able to hold those two positions at the same time. I also think refugee law does have already a possibility for individualized risk assessment, and to turn away, even in certain Article 33.2 of the Refugee Convention, people who pose a risk. But what you can't do, and I refer you to the Trump ban in 2017, you can't just say nationals of a country are all posing a threat to me. Certainly not under refugee law. And I'll have a look at that resolution, but it doesn't strike me as qualifying that. Thank you.
So Yuval had a rich question, and I'm not sure I'm going to be able to answer it completely, but I do want to touch on some elements. So first of all, part of our analysis is precisely based on the notion that these are military operations and that the duty to the constant care that you refer to applies. We also examine this argument that's been advanced by Jan Kleffner and by some others about this notion of proportionality as a general principle of the law of armed conflict. But beyond that, we do also look at the rules on attack. Part of that is by analogy. I won't get into, but we also do raise the argument that you can infer directly from those rules, not suggesting that the warning is an attack, but that it's causally and closely linked to an attack, and therefore those rules are applicable. And then your point that you make about this being not one attack, the rules on attacks, but you're supposed to do them one by one, and this is an overall. So that, I mean, that so there are a few things there. First of all, this is the kind of conceptual analysis. So we're not necessarily mirroring the issue that arose in the Gaza context, but there are some observations that I think are relevant for that as well. So I think when it comes to warning, certainly, if you're going to conduct a series of attacks in a locality, you can discharge your obligation to issue an advance warning by issuing a warning informing all the people in the area where you're going to be conducting these attacks that they should clear out. So I think it is possible to look at these warnings as a collective. Of course, each individual attack is going to have a certain level of civilian harm that you have to anticipate. I suppose what we're doing is sort of aggregating the civilian harm and the military advantage there. But I mean, I realize this isn't a complete answer on that. It's just that's the kind of core of the exercise. And then you pointed out this point about us not being well situated, I guess, to evaluate the alternative ways of achieving military advantage. And we perhaps consciously concentrate on the other side of the equation. So the points that we raise are about implementing measures to reduce the civilian harm rather than suggesting, yeah.
So before we thank our speakers, 3 housekeeping issues. First of all, I want to apologize to everyone else who wanted to ask a question, but our time really is up. So I would like to please ask you to join me in thanking all the speakers of today.